Good afternoon, ladies and gentlemen. We're back in session. We continued agenda item number 8, for the forward landfill, to this afternoon immediately after lunch, and we're back on that item. Staff was going to prepare some language for us in regards to a letter which was provided to us from counsel from one of the parties. So, and that letter has been given to us, so we'll give you time to give board members time to look at the proposed revision. And the addition here pertaining to DO, is there a monitoring requirement established for that? The last item here, the water and surface impoundment shall contain at least 1 milligram per liter dissolved oxygen, but is there a requirement in the monitoring plan?
Yeah, that's my understanding, yes.
Not your understanding, is it, or is it not?
I'll have to check, but
That's good.
yeah. Yes, because I remember talking about it.
Says, and come up, identify yourself and state yes, please, so we have it for the record. You need to turn on the mic.
Right here. Sorry. Ross Atkinson, Regional Water Board staff. Yes, the item before, the sentence before number 10 refers to Table 5, adding a requirement to monitor dissolved oxygen. This refers to surface impoundments. And so the sentence number 10 will add dissolved oxygen to a monitoring requirement, a weekly monitoring requirement for dissolved oxygen. And then sentence number 11 provides the limit, the concentration limit, must exceed 1.0 milligrams per liter.
Thank you, and since I had administered the oath, is what you just stated the truth? If so, answer yes, or I do, or whatever.
I do.
I do, thank you. Any further questions, comments, members of the board? If not, we can then consider this for voting. Is there further discussion, or do I have a motion?
Have we done the hearing yet?
Yes, we're
We
in the
have?
middle of the hearing. We continued the hearing.
We continue. the-
Okay, so I don't recall hearing whether there was anyone opposed or anything like that.
Well, nobody stood up for the other side,
Okay.
so we went to the short.
There's no
Basically-
one contesting the hearing that I'm aware of.
No, it's basically amongst ourselves with staff. Okay, with that, with the amendments, late amendments based upon the letter which was admitted into the record.
As well as the late revisions that were provided on the one page.
And the late revisions. Are there any further discussion, or do I have a motion?
So moved.
Sandra moves, and that's with the late revisions.
Yes.
Is that correct? Do I have a second?
I'll second.
Carmen seconds. Any further discussion? If not, we'll go to voting. This is a voice vote. All in favor state so by saying aye.
Aye.
Opposed, say no. Abstention, motion carries. That'll take us then to item number 11 on the agenda today. Get moved around here. Don't need that. You got cards for me, good. Okay, this is the time and place for a public hearing to consider an administrative civil liability order for the Reeve Road Heifer Ranch in San Joaquin County. The designated parties for this proceeding are as follows: the board's prosecution team and Henry J. Tosta. The prosecution team has a combined total of 45 minutes for direct testimony, cross-examination, and a closing statement. Henry J. Tosta also has a combined total of 45 minutes for the same. Interested persons shall limit their comments to 3 minutes. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer I do. Thank you. This time, evidence should be introduced on the following issues: whether the board should issue, reject, or modify the proposed ACL order. The order of this testimony is as follows: testimony by the prosecution team, followed by cross-examination, then testimony and cross-examination of Mr. Tosta. We'll then receive comments by interested parties. Finally, a closing statement by Mr. Tosta, followed by a closing statement from the prosecution team. Following that, the board will take this under consideration for voting. Please state your name, address, affiliation, and whether you have taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit a speaker card over here to our administrative assistant, Ms. Tang. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Just one minor housekeeping item I wanted to mention to the board. The advisory team is this time for this proceeding is composed of 4 individuals: myself, Ken Landau, Alex McDonald of the Regional Water Board staff, and Richard Lunkarovich, who is sitting in the audience right now. So we might be relying on any of those 4 to respond to your questions.
Thank you very much, Alex, for making us aware of your total team. We'll now begin with testimony by the prosecution team.
Good afternoon, Chairman Longley and members of the board. My name is Charlene Herbst, and I'm the Senior Engineering Geologist for the Confined Animal Facilities Unit in the Rancho Cordova office. Before beginning the presentation for item 11, I wanted to briefly go over late revisions to the item. They should have been passed out to you. They're in the form of non-substantive changes to Attachment A of the Draft Administrative Civil Liability Order. Does everyone have a copy of this? Okay. Attachment A describes the specific factors considered in setting the proposed amount of the ACLO. The changes made are shown in red on your copy and include changing references to prosecution team to regional board, updating dates to 2014 from 2013, and the addition of clarifying language to the ability to pay section on page 10 under step 6. There were also minor grammatical changes. Are there any questions about the late revisions?
Yes, it's been brought to my attention that, okay. Certain individuals who are part of this issue are not in the room, and, okay, continue. So, so far we have gone through the swearing. We've introduced this item, and we've asked individuals who are going to testify to take the oath. Is there anybody present who has not taken the oath who will be testifying? If so, please stand and take the oath. Thank you. Is the testimony that you will be giving the truth? If so, answer I do. Thank you very much. And I want to thank you, Carmen, and Jenny for pointing that out to me. And then we were just in the process now of beginning testimony by the prosecution team. And if you could just briefly give your time back, briefly begin where you were so everybody hears the testimony.
Before beginning the presentation for item 11, I wanted to briefly go over late revisions to the item which have just been passed out to you. The late revisions are all non-substantive changes to Attachment A of the draft Administrative Civil Liability Order. Attachment A describes the specific factors considered in setting the proposed amount of the ACLO. The changes made are shown in red on your copy and include changing references to prosecution team to regional board, updating dates to 2014 from 2013, and the addition of clarifying language to the ability to pay section on page 10 under step 6. There were also minor grammatical changes. Are there any questions on the late revisions?
We have none at this point. We'll come back to you later if we do. Thank you.
Good afternoon, Chairman Longley and members of the board. My name is Sean Walsh, and I'm an environmental scientist in the Confined Animal Facilities Unit in the Rancho Cordova office, and I have taken the oath. Together with Charlene Herbst, I am presenting for the board's consideration the recommended administrative civil liability for Henry J. Tosta, whom I will refer to as the discharger, for failure to operate the Reeve Road Heifer Ranch in compliance with the Dairy General Order and for failure to comply with Cleanup and Abatement Order R5 2012-0709. The discharger also operates the Henry Tosta Dairy, which was subject of an administrative civil liability order adopted 25 July 2013. The purpose of this presentation is to brief you on the basis of this administrative civil liability and to present a recommendation for the board to consider. I would like to note that this presentation does contain some graphic photos. The map on slide 2 illustrates the location of the Reeve Road Heifer Ranch. The Heifer Ranch is located 2 miles northwest of Tracy in San Joaquin County and a half mile west of the Henry Tosta Dairy. The Nagley-Burke Main Canal is located north of the Heifer Ranch production area, bisecting the Heifer Ranch cropland. If you look on your screen, I'm pointing out the Nagley-Burke Main Canal right now with my pointer. The dotted red line outlines the Heifer Ranch cropland, and the solid purple line outlines the Heifer Ranch production area. The solid orange line outlines the Henry Tosta Dairy. The Nagley-Burke Canal flows north and west, finally flowing into the Old River via an underground pipeline. The Old River is a tributary to the San Joaquin River, a water of the United States. The Heifer Ranch facility was initially operated as a dairy, starting in at least 1979. The discharger has leased the facility since at least 1994. The discharger contacted staff in fall 2011 to request that the Heifer Ranch be closed out of the Dairy General Order. On 1 May 2012, staff conducted a closure inspection of the Reed Road Heifer Ranch to determine if the Heifer Ranch was ready to be removed from the Dairy General Order. The Reeve Road Heifer Ranch is covered under the Dairy General Order. A report of waste discharge was filed for the Heifer Ranch in 2005. The Heifer Ranch was formally placed under the Dairy General Order in June 2007. The Dairy General Order contains provisions to ensure that both the production area, which contains corrals, waste and feed storage areas, and barns, and the cropland are managed in ways that are protective of groundwater and surface water quality. Among other provisions, the general order prohibits the burial of dead animals on dairies except in the case of a declared state of emergency and prohibits the stockpiling of manure. The dairy general order requires the cleanup of facilities prior to their removal from the order. The ACL complaint alleges 4 violations. A, that the discharger buried dead cows in groundwater, a water of the state, in violation of Dairy General Order Prohibition A6 and Water Code Section 13350. B, that the discharger failed to submit proof in a timely manner that the cow carcasses of Violation A had been removed and taken to a landfill as required by the Cleanup and Abatement Order, or CAO, issued on 11 June 2012. C, that the discharger failed to submit a groundwater remediation plan for the cow burial area of Violation A in a timely manner as required by the CAO. D, that the discharger failed to remove and properly dispose of manure containing animal remains that was located in the production area of the heifer ranch. The total of all penalties proposed in the complaint is $310,775. Next, I will discuss each of the 4 violations.
Excuse me, could you just define what you mean by collapse too?
Under the enforcement policy adopted by the state board, under certain circumstances, numbers of days of violation beyond a certain point can be, instead of counting as individual days, they can be collapsed to a single day. I believe it's for every 30 days of violation beyond a certain point, it counts as 1 day of violation.
And I suppose we'll get that under each of these violations, but you have a rationale for why these were collapsed then?
The collapsing can only occur under certain circumstances for certain types of violations. The Office of Enforcement folks could probably give you a more detailed explanation.
As we go through the testimony, then I would like to hear the rationale for why we're doing that.
We will provide that.
Violation A is the burial of cows in cropland underlain by shallow groundwater. On 1 May 2012, staff inspected both the heifer ranch production area and the cropland associated with the heifer ranch. In the course of the inspection, staff identified a cow burial area immediately south of the Nagley-Burke main canal. The burial area is identified by the red shaded area on this map. At the time of the 1 May inspection, staff saw 2 cows placed in a shallow excavation that was filled with water. Groundwater in the area is at a depth of 5 to 6 feet. Burying dead cows in a groundwater-filled excavation results in the discharge of waste to groundwater. Groundwater data will be presented in a later slide. According to the discharger, the dead cows came from the Henry Tosta Dairy, which is owned and operated by the discharger and adjoins the heifer ranch. The days of violation for Violation A has been set at number of days between the discovery of the burial by staff on 1 May 2012 and the date that the carcasses were removed, for a total of 56 days of violation. Although the penalty is based on the 2 carcasses identified in the course of the 1 May inspection, staff has reason to believe that many more cows were buried in the heifer ranch cropland. At the time of the 1 May inspection, Mr. Tosta told me that the cows were from the Henry Tosta Dairy and he had been burying cows like this for the last 5 to 6 years. On 1 May 2012, and during subsequent inspections, staff walked the field south of the burial area and north of the heifer ranch production area and found numerous cow bones on the ground. The photos above are representative of the conditions throughout the field outlined in yellow. Furthermore, the Tosta Dairy has never produced records for the period prior to the 1 May 2012 inspection that document proper disposal of dead animals using a renderer. Finally, after the CAO was issued, staff was contacted by Rebecca Hammond, who provided photographs showing the burial of cows. This photograph and others, which are Exhibit 11 in the prosecution team's evidence, were taken in late 2003 and early 2004. Staff was able to determine, using landmarks, that the burials shown in the photograph were located in the field south of the Nagley-Burke Canal and north of the Heifer Ranch production area. Note that the photograph is looking south to southeast towards the Heifer Ranch production area. The two red lines on the left identify buildings on the horizon of the lower photograph, and the red line on the right identifies the raised berm of the lagoon in the Heifer Ranch production area. The photograph confirmed the discharger's 1 May statement to me that this is a historical practice for the disposal of dead cows from the Henry Tosta Dairy. The CAO required that the discharger remove the carcasses buried immediately south of the Nagley-Burke main canal and provide proof of legal disposal. Violation B is based on the late submittal of the report required by the CAO, which was to describe the number of carcasses removed, how they were removed, and documentation of legal disposal of the carcasses. Initially, this cell phone photograph of a landfill receipt was the only proof of legal disposal provided by the discharger's consultant. Regional board staff eventually received a report describing the removal and disposal of the buried animals on 20 July 2012. The report is Exhibit 17 in the prosecution team's evidence list. A total of 18 days elapsed between the deadline in the CAO and the submittal of acceptable proof of legal disposal of the carcasses. Violation C is based on the late submittal of a groundwater remediation plan. The CAO required that the discharger collect groundwater samples in the vicinity of the cow burial area south of the canal. If the samples indicated that the cow burial had caused pollution of groundwater, the discharger was given a deadline of 27 August 2012 to submit a plan for the remediation of groundwater. Once the two carcasses that had been observed during the 1 May 2012 inspection had been removed, the discharger's consultant collected 2 grab samples of groundwater from the bottom of the excavation. The results of those grab samples are shown on this slide. The concentration of nitrate nitrogen in each of the samples exceeds the maximum contaminant level of 10 milligrams per liter. Per the basin plan for the Sacramento and San Joaquin River basins, the MPN for total coliform for groundwater with municipal use designation should not exceed 2.2. The samples from the excavation exceeded 2,000. Any concentration of E. coli in groundwater is of concern because, as stated in the U.S. EPA National Primary Drinking Water Regulations, E. coli only comes from human and animal fecal waste. Finally, the presence of ammonia in any concentration in groundwater indicates a close proximity to a waste source, as ammonia readily transforms to nitrate if exposed to air prior to percolation into the subsurface. Based on these results, the burial of cows in cropland caused pollution of groundwater and triggered the CAO requirement for a groundwater remediation plan. The requirement for submittal of this plan was reiterated in a letter to the discharger dated 14 September 2012, which is Exhibit 23 in the prosecution evidence list. A plan for the installation of groundwater wells was not received until 12 April 2013, 228 days late. The number of days of violation has been collapsed to 14 days using the enforcement policy. The final violation.
Well, we come up with that issue again, and maybe now's the time to address why you went to 14 days.
Certainly, I'd be happy to. This is David Boyers, counsel for the prosecution team. as we've outlined, we had 4 violations at issue. 2 of them we elected to, let's quote unquote, collapse days as provided under the enforcement policy. The enforcement policy provides that for certain days that extend beyond 30 days in terms of duration, an alternate approach to assessing liability can be utilized. And the purpose for that is because, some violations we see lasting for a very long period of time. And if you apply the maximum liability in those cases, the penalty gets very, very large. And so this tool gives the board the discretion. It's not mandatory, but it gives the board the discretion to collapse days if certain findings can be made. With respect to the second and third violations, which lasted longer than 30 days.
Well, before you go on, you said if certain findings can be made. Can you discuss those
Certainly.
findings?
One of 3 findings needs to be made in order for the board to collapse days. It either needs to be A, not causing daily detrimental impacts to the environment or the regulatory program. B, the violation results in no economic benefit from the illegal conduct that can be measured on a daily basis. Or C, the violation occurred without the knowledge or control of the violator, who therefore did not take action to mitigate or eliminate the violation. With respect to the violations C and D, the language that is both in the complaint and in the proposed order is that the violation at issue did not result in a daily economic benefit, and therefore it was permissible to collapse days using the approach as outlined in the enforcement policy, and that's what we chose to do. It's a method of coming up with a reasonable penalty at the end of the day. As I mentioned, it's discretionary.
By that, the board has the authority to decide whether they want to collapse or not collapse.
Absolutely.
Is there a calculation that's uncollapsed that you have?
No, we don't have that calculation in our back pocket, although I think it's pretty easy to do using the spreadsheet.
The final violation, violation D, is a failure to remove manure containing animal remains from the area south of the wastewater lagoon in the Heifer Ranch production area. The manure containing animal remains is identified by the turquoise shaded area on the map immediately south of the lagoon. These photos were taken 1 May 2012. At the time of the 1 May inspection, staff noted the presence of large number of animal bones and manure located south of the lagoon. The discharger told me that dead cows were buried in this area during the time that the Heifer Ranch was operated as a dairy. In the CAO, the discharger was directed to remove the manure containing animal remains and remove all wastewater and solids from the lagoon as part of the closure requirement for the facility. More bones were found mixed with manure solids from the lagoon when the lagoon was cleaned out. The manure and bones from the lagoon were stacked on top of the existing manure and bones.
Sorry, can you repeat the very first thing you said about this slide? Is it that these animals weren't brought from an off-site place? These are animals that either died or were dying on this site when it was being operated as a dairy? Is that right?
Yes, that's our understanding, is that these animals originated from the Heifer Ranch, either when it was operated as a dairy, or some of these may have come and put there when the Heifer Ranch itself was being operated, as opposed to the cows in cropland, which were imported from the dairy
Okay.
for disposal.
And is this area kind of from the previous slide, it looks like it's sort of in a contained area, almost like they didn't naturally just all die there. They might have died at different places and then brought here. Is that your understanding? And I can ask the discharger, but I just want to know what you have to say.
Yes, the animals you're seeing were placed in this spot.
Okay, thanks.
There. Tom Terpstra on behalf of the discharger. Could I ask Mr. Walsh to repeat the last line that he just told us that they were placed there? Is that your testimony?
Yes.
You'll have an opportunity to address that in cross.
Okay.
The presence of animal remains in the manure, as indicated by the presence of bones, renders the manure unsuitable for the application to cropland because pathogens that are resistant to decomposition may be present, including prions responsible for TSE, commonly known as mad cow disease. Board staff reminded the discharger and its agents of the requirement to dispose of manure containing animal remains at a landfill on at least 6 separate occasions and by letters dated 14 September 2012, 26 August 2013, and 29 October 2013. At the time the complaint was issued, the discharger was out of compliance for a total of 504 days, through 15 November 2013. Staff entered into discussions with the landowner regarding the need to remove the manure containing animal remains to a landfill. The discharger was not a party to these discussions and did not clean up the manure. Removal of the manure containing animal remains by the landowner began 18 November 2013 and was completed 17 calendar days later on 4 December 2013. Because of the lack of responsiveness on the part of the discharger, staff have invested a great deal of time in monitoring the progress of cleanup at the Reeve Road Heifer Ranch. A total of 15 inspections have been conducted, in addition to issuance of a cleanup and abatement order, 3 status letters, and a 13267 letter. Charlene Herbst will now continue the presentation.
Mr. Chair, I don't recall the format of this proceeding, and if you could educate me, I'd be appreciative of that. Do we have the opportunity to cross?
Following their testimony, you have the opportunity to cross.
So not on a witness-by-witness basis?
No, that's correct.
Thank
Once
you.
they finish, I'll be asking the board members if they have any questions, and after we get through that, I'll turn to you and ask you if you want to cross.
Thank you.
You're welcome.
Good afternoon, Chairman Longley and members of the board. My name is Charlene Herbst, and I am the Senior Engineering Geologist for the Confined Animal Facilities Unit in the Rancho Cordova office, and I have taken the oath. I will briefly discuss how the penalty was calculated for this complaint relative to the enforcement policy, and I will also discuss objections made by the discharger relative to our calculations. This slide summarizes the scores developed using the enforcement policy for each of the 4 violations in the complaint. Violation A, the burial of dead cows in groundwater, is a discharge violation, and the remaining 3 violations are non-discharge violations. Violations B and C were late submittals of reports. The higher culpability score for violation C reflects the lateness of the eventual submittal of the report. Violation D, the failure to remove manure containing animal remains, has maximum scores for culpability and cleanup and cooperation because the material had not been removed by the time the complaint was issued, and because the material was eventually removed by the landowner, not the discharger. The discharger objects to the scoring for violation A, contending that the deviation from requirements was minor, not major, that the burial of cows did not harm groundwater, and that dead cows were not routinely buried in Heifer Ranch cropland. The prosecution team contends that the discharger was well aware that the burial of cows in cropland was prohibited by the 2007 Dairy General Order, and that the results of groundwater samples collected from the burial excavation document pollution of groundwater. The prosecution team also contends that the presence of numerous bones in the cropland south of the Nagley-Burke Canal, as shown in Slide 8, the lack of Tosta Dairy rendering records, and the photographs provided by Rebecca Hammond and included as Slides 9 and 10 all indicate that many dead cows were routinely buried in Heifer Ranch cropland. For violations B and C, the discharger contends that, in each case, the late report should be counted as a one-time violation rather than multiple days of violation. This contention ignores the plain language of the statute authorizing the imposition of liability on a daily basis. The discharger offers no legal analysis for his interpretation of the statute, and therefore his contention that the reporting violation should be subject to only 1 day of liability should be disregarded. The discharger also contends that, because both reports were ultimately submitted, the culpability and cleanup and cooperation factors should be set at 1.0. The culpability of the discharger is assessed based on the reasonableness of the discharger's conduct, and a higher multiplier is used for intentional or negligent behavior. The discharger was fully aware of the need to submit the 2 reports in question. The fact that the discharger eventually submitted the reports has already been considered by the prosecution team in determining the proposed liability, and no further reduction from the current culpability scores of 1.3 and 1.4 for violations B and C respectively is warranted. The cleanup and cooperation score for violation B, late submittal of proof of legal disposal of carcasses, has already been set at a neutral multiplier of 1.0. For violation C, late submittal of a groundwater remediation plan, the discharger should have prepared the plan upon his discovery of groundwater contamination as indicated by groundwater sample results. Furthermore, staff reminded the discharger of the requirement to submit the groundwater remediation plan by letter dated 14 September 2012, but no plan was submitted until 7 months later. A factor of 1.4 was therefore assessed for cleanup and cooperation for violation C. Finally, the discharger contends that he has a financial hardship which should be taken into account in setting the penalty for violations B and C. The discharger's evidence does not support his contention of inability to pay. Dr. Gerald Horner, State Water Board economist, prepared a detailed rebuttal analysis of the discharger's claims of inability to pay and continue in business and is available to testify as an expert witness. It should be noted that many dairies have financial problems but do not exhibit the kinds of issues found at the Reeve Road Heifer Ranch. The discharger contends that for violation D, there should be no penalty assessed at all because the stockpile of manure and animal remains has been completely removed, and that many of the delays with the removal process were attributable to the failure of the regional board staff to render consistent and timely advice and assistance, both internally and vis-a-vis other governmental agencies. Directive 4 of the CAO expressly required the discharger to remove the manure and bones in the area south of the wastewater lagoon and export bones to a landfill by 29 June 2012. In a letter dated 14 September 2012, Regional Board staff informed the discharger that the stockpiled manure and bones must be disposed of at a landfill certified to receive animal remains. This requirement was reiterated verbally during inspections and in writing by letters dated 26 August 2013 and 29 October 2013. The discharger and his consultants requested permission from the Regional Board to apply the stockpiled manure to land rather than remove it to a landfill because land application would be less expensive. Regional Board staff allowed the discharger to explore this alternative with other state agencies having jurisdiction over land application of manure containing mammalian tissue, but made it clear to the discharger that written approval from other state agencies was required before this material could be land applied. The discharger has never obtained written approval for land application of the material from any state agency. In the end, it was the landowner, not the discharger, who contacted Regional Board staff and who removed the material to a landfill. There is no evidence that the discharger has paid for any part of the cleanup costs. Because the landowner, not the discharger, remediated the problem, no credit is due to the discharger for the remediation. Finally, the discharger contends that because the ACL order adopted by the Central Valley Water Board on 25 July 2013 for the Henry Tosta Dairy is currently pending review by the State Water Resources Control Board, and because it is unrelated to the current violations, it should not be used to increase the multiplier under history of violations for violations A, B, and C. The ACL order for Henry Tosta Dairy was adopted after a hearing and was based on findings that the discharger had unlawfully discharged manure waste to groundwater, failed to submit an adequate waste management plan, and failed to comply with directives of a cleanup and abatement order. The fact that the discharger has petitioned this order to the State Water Board does not act to stay the Regional Board's findings of violation. The recent violations by the discharger at the Henry Tosta Dairy are similar in nature to those alleged in this complaint. Therefore, the prosecution team was conservative in its use of the minimum multiplier of 1.1 for history of violations. No reduction is warranted. While we are asking you to consider imposing a liability for violations at the discharger's heifer ranch, we wanted to show you the current condition at the discharger's dairy. This video provides an indication of the discharger's existing management practices. Regardless of any claims made by the discharger regarding his ability to pay and continue in business, the prosecution team contends that the condition at the dairy and the violations at the heifer ranch warrant imposition of the proposed liability. This video was taken on 9 January 2014, looking into the freestall barn at the Henry Tosta Dairy. Slurry manure is ponding inside the freestall barn and collecting in the corrals.
Mr. Chairman, before the board hears the video or watches the video, I would like to offer a continuing objection to this and any other evidence submitted in connection with the Henry Tosta Dairy. The Henry Tosta Dairy was the subject of a previous ACL complaint last summer and has been fully adjudicated, at least at this level, by this board. I fail to see how it is relevant. I fail to see how it is pertinent to what's happening on the Breve Road heifer facility, which is the subject of this ACL complaint, and on that basis I offer that and a continuing objection to any evidence pertaining to the Henry Tosta Dairy.
I'll rule on your objection and I'll sustain it. I think that the evidence that you're about to present on the dairy is not relevant to this proceeding.
Okay.
And your testimony prior to that on the dairy, I order that be stricken from the record.
Is there a reason for that? I'm not sure.
And may the prosecution team respond if you, this is David
I'd like
Boyers.
a little discussion on this if we could.
Well, certainly. This issue is on this other site and is not on the dairy. We previously acted on the dairy. So, counsel?
Sure. If I might make 2 points. Number one, the discharger has had this piece of rebuttal evidence for 3 weeks, and this is the first time we're hearing of this objection. So I would first contend that it is untimely. The second point I would like to raise, which is contained in our rebuttal submittal, is that the discharger has contended that he is unable to pay this liability. And implicit in that argument is the idea that the liability should be lower. We think that it's very important that the board understand the current state of Mr. Tosta's practices, not only at the heifer ranch, but at the dairy, in order to consider the appropriateness of the liability that we are proposing. You can find that even though he has the inability to pay, we still think it's an appropriate liability. And we think all the factors, all of his business practices and how he's operating are relevant to that consideration. And that is why we offered it 3 weeks ago in our rebuttal.
Can I? Comment?
Alex?
Oh, I was just going to comment my opinion. Do you? I don't know. I would say in response to what counsel just said, as far as, you know, the fact that, or the contention that the defendant or the discharger somehow waives an objection to evidence because they didn't raise it timely, I don't think that that's sound. I think that it's fair for them to raise the objection at the hearing. So I don't think that that objection is waived. So that's just my opinion. But as to the second part, I don't know. I as far as inability to pay, I kind of tend to agree with the chair that this is not relevant at this time. I mean, I think that I kind of, in my mind, go to the, you know, is it more probative than it is prejudicial? And I don't think it is. I think it's more prejudicial than it is probative. But I'll ask our counsel to weigh in as well.
Yes, Alex.
Yes, Mr. Chair and board members, I concur with Board Member Ramirez's first statement regarding timeliness of objections. Um, Objections to evidence being introduced at a hearing are timely at the hearing itself. With respect to the second point that was being made about the relevance of this evidence, that question involves more discretion by the board. It's more of a judgment call. The definition of relevant is very broadly interpreted in administrative hearings, and therefore, if the ability, like the prosecution team was mentioning, if the ability to pay or continue in business becomes an issue at this hearing, the board finds that there is no ability to pay, then at that point, it does become relevant to determine whether the proposed penalty should be assessed despite the lack of ability to pay or to continue in business. And since that question is directed at the discharger, the named discharger in this ACL is Henry Tosta, who operates this facility, the facility at issue, which is the Heifer Ranch, and the Tosta Dairy, which is the subject of this video. There's arguably some relevance to that question if it does come up. At this point, it's not clear whether that question is going to come up. So perhaps there would be an ability to reserve judgment on this question until later, until it becomes clear whether that particular issue about the ability to continue in business despite lacking an ability to pay is a question for the board. So that would be my recommendation, is to defer the ruling until it becomes relevant.
Chairman Longley, I think that even though I agree with what Mr. Mayor is saying, I think that this video of cows, I assume walking around in whatever this is, I think that if Tosta Dairy was willing to stipulate that they do have another business, I don't know that this video is relevant. I do think it's going to be, in law we say you can't unring a bell. Once we see this video, you can't go back. So I think that if they're willing to stipulate as far as, that they have another operation, then I think that the probativeness of this video goes way down, and I think the prejudice stays really high. So, and with
Mr.
that,
Chairman,
I'll close.
And I appreciate Commissioner Ramirez's comments, and I concur. I would stipulate that Mr. Tosta does operate a facility adjacent. It's been shown on the maps, and I have not objected to that testimony. What I do object to is somehow linking the fact that he operates a dairy with the video that you're about to see and how that has any relationship at all to the ability to pay. In my mind, there's nothing in the prosecution's argument that even resembles a shred of legal argument.
My decision stands.
Thank you.
Based on the methodology for liability calculation of the enforcement policy, the prosecution team recommends that the board make findings of fact and conclusions of law affirming complaint number R5-2013-0592 for a liability of $310,775. A proposed administrative civil liability order is included in your agenda package. I would like to submit this presentation, the agenda package, and the Central Valley Water Board files referenced in the agenda package into the record.
Are there any questions by board members?
No, but I would guess that the entire submittal that's being entered into the record is going to strike the video. Just to confirm, that's right?
It should.
That's correct. We'll make sure that occurs.
Thank you. Counsel for Mr. Tosta, I have your name here, and unfortunately I have is it Terpstra?
It is Terpstra.
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 Terpstra, okay. The procedure at this point is you have the ability to cross-examine. And following that, we'll be asking for testimony by Mr. Tosta or his counsel.
Thank you.
And the total time allowed for all of that is 45 minutes.
Thank you, Mr. Chairman. And before I cross-examine any of the witnesses, it's unfortunate that we were a bit tardy from lunch. We had didn't have an opportunity to be here at the introduction of this item. I had intended at that time to offer a renewed objection to the hearing procedures and request that this item be continued until the State Board has considered Mr. Tosta's petition for review that was filed last year. Because the site has been cleaned up per the work plans and there is no prejudice to any party by continuing this item, it was my thought that what we call judicial economy would be served by not having this hearing, because if the State Board concurs with Mr. Tosta's due process arguments in the petition for review, it's very likely that that hearing would have to be conducted over again, and that this hearing, by extension, would have to also be conducted over again. This is, to be sure, an emerging body of law in California, but it's becoming clearer and clearer under the Saby case, the most recent case, Saby versus City of Pomona, that an attempt to separate the prosecutorial and advisory functions in a setting like this is ultimately not going to be successful. And again, California law is evolving in this area, but Saby stands for the proposition that separating those functions is inherently unfair to, in this case, the discharger. And for that reason, we object to the composition of the advisory team and the prosecutorial functions, and would ask that the hearing be continued until the State Board has an opportunity to weigh in on that issue and possibly for that issue to be litigated as well. So I would have offered that at the beginning, but again, I apologize
That's
for the
fine.
tardiness.
And,
Took a while to get a lunch ticket today.
You'll get the same ruling either place. I'll deny that. So you'll continue with, unless you have other objections, I'll continue with your cross-examination.
Thank you. We would like to just ask a few questions of Mr. Walsh, if we could. Thank you, Mr. Walsh. Your testimony today in front of this board had some discussion of the bones found in the lagoons.
South of the lagoon.
Correct, and these were excavated. Is it your contention that that there is evidence that these bones were placed there by Mr. Tosta or his operation?
My statement about bones, I was more referring to the cat. There were also calves in that picture.
Mm-hmm.
And ask me the question again, Mr. Terpstra.
Yeah, is it your contention that the bones were placed there or caused to be placed there by Mr. Tosta or anybody working for his operation?
Yes.
And what evidence do you have of that?
During the 1 May 2012 inspection, Mr. Tosta told me while he operated a dairy there, that's where he buried his animals.
Could we place the map back up, please, that you used? Could we possibly get that back up on the screen?
So the area that I'm talking about is shaded in turquoise.
Yeah, for me, I'm color challenged. You're saying the blue area, right?
That's correct.
Thank you. Okay. And your testimony today is that Mr. Tosta told you that in that area, that's where he had buried animals. Is that correct?
Yeah, that what Mr. Tosta told me. Also, walking that area, it was dense with manure and bones.
Yeah.
Not just old bones, but fresh hide, halfway decomposed calves, calf parts. That's what was in that area. Also, one last thing is I believe a piece of evidence that you submitted, Mr. Tosta he confirms he's been burying animals in that area, I believe, from 2008 to 2010. So,
I believe Mr. Tosta's testimony. Well, we'll let Mr. Tosta testify to that, I suppose. Thank you. And then you testified, you had made some mention of the evidence of mad cow disease apparently in this area?
I
Did you-
didn't mention mad cow in that area. Somebody, possibly Charlene would want to speak on that.
The comment about mad cow disease was in reference to limitations on land application of mammalian tissue, of material containing mammalian tissue to cropland. And if your point is that mad cow disease is very rare in the United States, that is correct.
I'm sorry, Charlene.
Yes?
Can you wait for him to ask this
I'm
question?
sorry.
It's
I'm
okay,
sorry.
because I don't even know what question he was going to ask.
No, I was, yeah, correct. I wanted him to refresh or restate his testimony as to the existence or potential for mad cow disease as a result of the alleged placement of these animals in this location.
Did she answer your question?
She was beginning to.
Okay, all right, so
I
go ahead and answer his question,
And I am
please.
finished with my questioning of Mr. Walsh, so I was going to transition to
Okay.
Ms. Herbst at this point.
Well, why don't we let Ms. Herbst finish answering that particular question, and then we'll proceed on.
Okay.
Fortunately, TSE or mad cow disease is rare in the United States, but because of the gravity when it is present.
I think the question to you, what was your statement?
My statement was that because of the potential for TSE, there are restrictions on the application of material containing mammalian tissue on cropland.
Thank you. You continue with your question, sir.
Thank you. In your testimony, Ms. Herbst, you mentioned that there had been documented pollution of the groundwater as a result of the burying of the animals on the site. Is that correct?
That's correct.
Okay. The actual language in the administrative civil liability complaint is that staff inferred damage or pollution to groundwater. Is that correct?
Can you let me know which page you were referring to?
I knew you were going to ask me that. You're going to have to give me a moment. I believe the language is staff reasonably inferred. This is page 5 of the prosecution team's rebuttal. I'll read it. After analyzing the potential for harm to beneficial uses of decomposed cow carcasses and the physical, chemical, and biological characteristics of decomposed dead cows, and taking into consideration the observations of staff, the prosecution team reasonably inferred. So what you're telling us is that staff had no prior sampling that would indicate whether or not the burial of the animals had materially degraded groundwater in the area. You're aware that in previous proceedings in front of this board and in his work plan submittal dated April 10th, Mr. Minnie very clearly states in that submittal that background water conditions up gradient are as bad or significant, or as bad or worse than groundwater conditions near the monitoring wells in this area. And so Mr. Minnie very clearly indicated in that submittal that groundwater conditions hadn't gotten worse as a result of this, but that groundwater had already been substantially degraded. Isn't that true?
I think there's two questions there.
If I might
I'd
just,
be happy to restate it.
may I just make an objection? The report from Mr. Minnie that I believe Mr. Terpstra is referencing is in relation to the Tosta Dairy.
No, it isn't. It is a submittal that he offered in a work plan submittal that he offered that is referenced in your papers. It was referenced as being offered late, but nonetheless in that work plan submittal, Mr. Minnie very clearly indicates. I'm going to have to squint here to read this, but I will pull it up. If you want to continue your objection, you can.
No, that was the extent of my objection, and if you could tell me where specifically I can find the Minnie report that you're using, I would appreciate that.
I think before we go ahead and answer that, it's important that that be found.
Mr. Chair, I believe I'm aware of that document as well, so I'll be searching for that
Okay.
if I can be of assistance.
Mr. Minnie Mr. Minnie's groundwater remediation plan submittal says the following: the shallow groundwater in this area is of very poor quality. The background water levels that follow were recorded at the former sugar beet factory 2 miles east of this site. The most relevant groundwater parameter is TDS. The secondary MCL is 500 mgl per day, and the background shallow groundwater is obviously not suitable for drinking water. Most of the shallow groundwater in this area, as demonstrated above, is not treatable to drinking water standards.
Can you point to the exhibit that you're referencing?
Believe it's the submittal itself is referenced in your moving papers. I'm not sure if it's in our response papers.
Is it your exhibit 8?
If I could interrupt, I said that I was going to look for this potential mini report. There's an exhibit 27 in the prosecution team's evidence list that is a cleanup plan written by John Minnie.
No, that's
If we could confirm from Mr. Terpstra that that's it's dated October 23rd, 2013.
Yes, that references it as well. I was reading from an earlier version, but you're correct. That's the version that's in the packet.
That's the version you should be working off of.
Thank you. So let me just, is it staff's position that groundwater in this area is not substantially degraded prior to or in that area up gradient, for example?
Are we, just so I know where we are in the questioning, have we gone beyond the reasonably inferred question?
Well, I guess I would ask you why the language in the prosecution team's rebuttal doesn't say that it was definitively established that groundwater had been deteriorated or degraded as a result of this action or this alleged action on behalf of Mr. Tosta. But in fact, the language says that staff reasonably inferred. And my question to you was going to be, on what basis did you make that inference?
Okay, let me respond to that before we go on to the questions about the Spreckles sugar beet factory. We have one piece of groundwater data in the area that's bordered by yellow, and that is the 2 grab samples that were taken from the excavation where the animal remains were removed. There is no question in staff's mind that at that point, based on those 2 analyses, groundwater has been polluted by that burial. The point that's in the rebuttal evidence that Mr. Terpstra is referring to talks about a broader determination about groundwater contamination throughout the area. We have 2 data points from one location. However, we are reasonably inferring that those types of burials would have impacted a broader area if they're, depending on the scope of the burials, which we, as we've already discussed, do not know. We just have, some evidence about the scope of the burials in the area. And that's why that language was chosen for this rebuttal document.
This is Rob Busby, supervising engineer and geologist. I'm taking the oath. I just took to elaborate on what Charlene was saying. It was in the presentation, the table that showed the results from the samples taken from that area where the cows were buried. And there's some clear indicators, I'm also a hydrogeologist, there's some clear indicators of direct correlation between the cow burial and water quality. One is the fact that you only have around 5 to 6 feet to groundwater, so this is essentially a direct discharge of a cow into groundwater. 2 is you're seeing ammonia, which is, like I think we talked about in the presentation, is typically not stable in a groundwater environment. It's rapidly transformed to nitrate and then nitrate. So you would not expect to see ammonia a considerable distance from the source. And then on top of that, there's some other, then there's extremely high TDS. And the other thing is, in terms of what I guess, Minnie's report, which isn't really necessarily directly germane to this location. It's more of a kind of overall statement. Something that's going on in a sugar beet factory 2.5 miles away is very irrelevant. Here we have, it might be more relevant if it was 50 feet or 100 feet to groundwater, but here with 5-6 feet to groundwater, especially in an effluent-dominated situation, what you get in groundwater is very reflective of what's going on immediately above. Again, that logic doesn't apply if your depth to groundwater is 50 or 100 feet, but for a situation like this where it's essentially a direct discharge, what you see in groundwater, it's effluent-dominated
Okay,
water body.
let's get back to Mr. Terpstra. You have any further questions?
Yes, I do, thank you. And I appreciate the additional commentary by your staff. I wasn't cross-examining Mr. Busby, I was cross-examining the staff that testified, but to the extent they want to offer additional information, that's within the discretion of the chair. Ms. Herbst, you testified as to the reasonableness of the timing associated with this and the reasonableness of the discharger's action with respect to submitting, with respect to item 1, I believe, and item 4, which is the timely submittal of the groundwater remediation information and the timely submittal of a work plan and subsequent disposal of that material. I want to ask if you were present in any of the meetings that occurred, particularly as to the disposal of that material between the discharger and the landowner and RB5 staff and other officials.
I was present at meetings that were involving this discussion, yes.
There was a meeting on January 7th of 2013. Were you present at that meeting?
I'd have to check my notes to be able to answer that.
Okay. There were in fact meetings in January, February, April, and in April prior to the time Mr. Minnie submitted the respective work plans, at which the exact parameters of the work plans and the exact parameters of the disposal effort were outlined for staff. Is that correct?
The date of the work plan that actually talked about removing the material was not received to my knowledge until October. Yeah, I think it was October 2013.
Serbs, you testified, well, let me ask you this. In terms of the material that was to be removed and the iterative process between the discharger and particularly the landowner, his representatives and staff, what additional harm, if any, can you testify occurred by that material staying on the premises during the time that it was attempted to be worked out for an alternate disposal method besides going to a landfill? Was there any rain during that time or any of that material discharge or leach into groundwater?
There was no monitoring of groundwater in the area that would have allowed that kind of a determination to be made.
Okay. But okay. In your discussion of the penalty calculations and the penalty assessment, you talked about there being no credit for the discharger, Mr. Tosta, because the landowner ended up doing the heavy lifting, as it were. Is that correct?
That's the statement in the presentation, yes.
Yes. Does it surprise you, would it surprise you that the landowner in this case, being the holder of fee title to this property and not a mere tenant, would want to have an active role in the removal of this material?
No.
And you were aware, and you are aware at this point, that Mr. Tosta had reached an arrangement that due to his own financial situation and his own inability to pay for all of this retaining of experts and the development of the plan and the ultimate disposal of this material, had reached an arrangement with his landowner, his landlord, for the landlord to undertake this work on his behalf. Is that correct?
That statement has been made. I have seen an agreement that has only Mr. Tosta's signatures on it. I haven't seen a completely executed agreement.
So it's your contention then that unless there's an agreement that's been signed by the landowner as well. Unless you have that copy submitted into evidence, you don't believe that the landowner has reached an arrangement with the landlord. Is that correct?
Well, I have not got evidence that the Echeverias are a party to the agreement you're referencing.
Okay, well, I suppose we'll have Mr. Tosta testify to that. He's the one on the evidence list. But, okay, that concludes my cross-examination of Ms. Herbst. Thank you.
And does that conclude your cross-examination of other staff that testified?
Yeah, the only other, I guess I would ask just as a procedural question, is Ms. Hammond going to testify today? I would like to cross-examine Ms. Hammond with respect to the documentary evidence that was introduced in this hearing.
I can
She
speak, I
testified
can speak to that.
Let me finish, if I could. She offered testimony as to burial practices on this dairy dating back to 2003, or this facility dating back to 2003. Her testimony was obviously relied upon by the prosecution team. To the extent she's not here, I move that her entire testimony be stricken. We have no opportunity to cross-examine her.
I mean,
She
but
was
you,
listed on the evidence list.
but you could have
this-
subpoenaed her, right?
If I might, David Boyers for the prosecution team. I did issue a subpoena to Mrs. Hammond, or to Ms. Hammond, to appear and testify.
Yes.
She did not comply with that subpoena, and she is not here. We expected her to be here, and she is not. However, if I might just note that the expert witness for the discharger also is not here and has submitted a declaration for which we have no ability to cross-examine. That declaration was admitted. I would ask that the same be allowed of Ms. Hammond's testimony. We understand that the testimony is hearsay. It is not being offered alone to support a finding, and I would ask that it remain in the record.
Alex?
Yes, Mr. Chair, Mr. Boyers recalls a ruling that you made regarding the Furman declaration, and the chair ruled that evidence, that declaration would not be excluded from the record because there is no absolute right to cross-examination guaranteed by a cited government code section that we abide by in these proceedings. And in fact, that government code section explicitly allows hearsay evidence to be admitted into the record over objection by any party, as long as that hearsay evidence is used to supplement other evidence in the record, and as long as that hearsay evidence is not the sole support of any particular finding, and unless Mr. Terpstra can explain what particular finding he believes is solely supported by this hearsay evidence, I would suggest that this evidence be included in the record.
Mr. Terpstra?
We'll leave it to the chair's discretion. Thank you.
Well, can you provide evidence that this is the sole basis upon which that judgment was made?
And I don't think it's my burden to do so, Mr. Chairman.
Well, then I'll overrule your objection. Very good. Any further cross-examination?
Well, and I don't want to go back to the point you just overruled, but I don't think it's incumbent upon us to show that that evidence is the only evidence that is used to support a finding. To the extent it contributes to the making of the finding, it is within our rights to ask for cross-examination. She was
Certainly,
subpoenaed,
but
she's not here.
And Dr. Longley?
You've heard the advice given to me by counsel, and yes.
Dr. Longley, I think that your ruling is correct. I think that if we have the right to rely on hearsay evidence, I think as long as our final decision is not solely based upon the hearsay evidence,
Exactly.
I think that you were right to admit it, so I would support
Thank you.
that.
Thank you. So, if you have no further cross-examination, then we're ready for testimony by Mr. Costa, Mr. Costa's representative.
Thank you. I'll be offering the testimony today on Mr.
Thank you.
Tosta's behalf. Mr. Tosta's dire financial situation is detailed in his declaration. He lacks the resources to retain Dr. Furman for the purposes of testifying at this hearing. or even to update his report from last summer. He lacks the financial ability to retain Mr. Minnie, who previously testified as to the substantially degraded groundwater conditions under both the Tosta Dairy and the Reeve Road Heifer facility. He lacks the financial resources for a full and adequate legal defense, which ideally would include expert testimony as to the lack of degradation of groundwater, the inability to pay, and the underlying unfairness of these proceedings in relationship to due process. Instead, today you have in front of you myself and Mr. Tosta, and I'm essentially working pro bono on his behalf. It's not an overstatement to say that Mr. Tosta would be better off, at least in terms of defending himself, if he had been accused of these acts in a criminal context. At least then, if he had been charged with a crime, he would have been provided with a vigorous defense by the public defender's office or somebody of that nature, which itself would have access to qualified groundwater experts, financial consultants, and the like. But Mr. Tosta was not charged in a criminal context. He was charged in a civil context. And as such, it's incumbent upon him to pay for his entire defense. And as we testified, and as Mr. Tosta testified in his declaration, he lacks the cash flow and the resources that are necessary to mount that type of defense. The original ACL complaint for the Reeve Road property was issued in 2012 against Mr. Tosta and the original property owner and the landlord, the Echeverria brothers. As Mr. Tosta's declaration attests, following the regional board's imposition of liability on the Tosta Dairy in the amount of $685,000, and as a result of other and continuing financial setbacks, Mr. Tosta was not able financially to hire the consultants and experts to prepare the necessary work plans and to carry out the work necessary to comply with the cleanup and abatement order. At Mr. Tosta's direction, and as his attorney, I began discussions with the property owners, the landlord's representatives, for an arrangement by which the hiring of the necessary consultants and the experts and the cleanup work would be completed by the property owner with subsequent reimbursement by Mr. Tosta. The necessary work plans were developed over a period of time, as we attempted to show in our discussion, our cross-examination of your staff. It was an iterative process, particularly with respect to the disposal of the commingled remains and the manure. Put just very simply, it costs a great deal more money to haul that material to a landfill than it does to either land apply it or compost it. Land disposal is infinitely cheaper and preferable, but after a great deal of effort and a great deal of discussion with the Department of Public Health and the CDFA, California Department of Food and Agriculture, staff makes it sound easier than it is to get written concurrence that you can dispose of this type of material on land. And that effort, after many months of back and forth, many meetings, many emails, many telephone conversations, that effort was suspended, and ultimately this material was hauled to a landfill where it has now been properly disposed of at that venue. So all of the necessary compliance work has been completed, and at least with respect to the disposal of the material, the inability of your staff to coordinate with Mr. Smith and his consultants representing the landowners and to get timely answers to the questions that were raised pertaining to the disposal of that material contributed greatly to the delays that are now charged in this complaint. And on that basis, we believe that the liability amounts should be reduced because a good faith effort was being made to comply. A good faith effort was being proffered to develop the study plan, the work plan, and to develop a means of disposing of this material. It isn't that your staff or the board was being ignored. Now, Mr. Tosta, as I mentioned, has executed an agreement with the property owner landlord. A signed copy of that agreement has been submitted. It is signed by the party to be charged, which in the law means it is binding upon Mr. Tosta. It has been signed, and I will represent to you as an officer of the court and as an attorney representing Mr. Tosta that it has been fully executed by all parties and that security has been put in place to secure Mr. Tosta's obligation to fully reimburse the landlord and the property owner for that work. So Mr. Tosta is committed, as you can see from the agreement, to a maximum amount of $175,000 to reimburse his landlord for the work that was done. Initially, this ACL complaint was issued against both of the parties, and both of the parties, working in concert, developed a means of responding and getting this work done. Mr. Tosta's role in this process should not be diminished. He is the one who is financially responsible for this work and for compliance. And so the issue today is not whether the necessary work will be done or even how it will be paid for. It has been done, and Mr. Tosta has assumed financial responsibility. And I believe that is a factor in mitigation. I believe it is a factor that should be considered, and we would respectfully request that the amount of the penalty that is imposed in this proceeding, especially in view of the fact of the $685,000 penalty that was issued last summer, for which Mr. Tosta has absolutely no hope of paying in the short run, that the board would exercise its discretion and some leniency in this matter in view of his attempts to comply. I can ask Mr. Tosta to testify, but basically everything that he wanted to say in this matter is contained in his declaration. He has attempted to comply. This is not a bad faith move on his part. It's simply a lack of resources. And on that basis, we would submit.
Thank you. Mr. Tosta, do you wish to add anything to what your attorney said, or does that testimony stand? It's Mr. Tosta so indicated that that testimony stands. Very well. Ready for cross-examination by, well, first of all, any questions from board members? Cross-examination by staff?
Mr. Chairman, Mr. Tosta has not testified. I don't know that he can be cross-examined at this juncture.
Oh, you're sitting as
I'll
attorney.
make it easy. Mr. Chair, the prosecution has no cross-examination.
Very good. That makes it easy. That's right. You're representing as attorney. Excuse me, sir. With that,
I guess I'll have a question.
sure.
And even though he's not, Mr. Tosta's not testifying, there was some discussion about, or in your cross-examination, you asked staff how they knew or where they got the information that the animal remains had been placed there by either Mr. Tosta or one of his agents. And you said that there would be some testimony as to that. So I don't know if you're prepared to answer that, or if you were going to have your client, or if you're going to waive that issue.
I think upon reflection, I think the evidence that was there speaks for itself, and I would offer nothing further in that regard. Thank you.
I have a card from a Hugo
Mr. Van Vliet had to leave. He has to be in Oregon. I
Okay.
don't know. I believe I think there may be one other speaker who may not have submitted a card, but I'm not sure who'd speak it just as a member of the
Okay,
public.
fine. We'll move on to interested parties. Mr. Lee Smith? Thank you. Is there any other interested party wishing to testify to this board? Seeing none, Mr. Terpstra, do you have any closing statements?
I would waive any closing statements. I think I made them in the body of my remarks. Thank you.
Thank you very much. Closing statements by staff?
Yes, Dr. Longley. I just wanted to sort of reiterate a couple things. And the first is that that our staff, as was noted in one of the slides, spent a great deal of time working with this discharger, and that there were many opportunities along the way to correct the issues at hand and to come into compliance. And I did want to point out that although we are not asking for staff costs in this, that I just wanted to make the board aware of the large amount of staff time that did go into this, that we estimated conservatively around 2,000 hours of staff time between all the inspections and the other things. But again, we are not asking for any of that as part of this penalty. And just to close, I mean, we believe that the proposed penalty is based on a pretty conservative assessment of the factors in the enforcement policy and the discretion allowed by it. And we would ask that you adopt the penalty as proposed.
Thank you. Any further questions of staff or the discharger before we close? I'll close the hearing then, and we'll confine the conversation to our advisory team and ourselves, and determine how we're going to dispose of this issue. Yes.
I just wanted to, I know we have a groundwater expert here, but we have Mr. McDonald, and there was some discussion about whether there is a direct correlation between the burial of the cows and groundwater contamination. I wanted to just get your 2 cents on that as well.
Sure. If you actually look at, there was 2 times groundwater sampled in that location. One time, right after they removed the cows, they sampled the water that was in the bottom of the pit, and that's the data you saw on the slide there. So that the concentration of nitrates were really high. Later on, they actually put in temporary monitoring wells, right within 2 within the barrel of the pit, in the pit area, and then 1 off a little bit farther to the west. And if you look at that data, all of a sudden the nitrates are gone. So they moved the cows. When the cows were there, they had high nitrate concentrations in the groundwater. Take out the cows, nitrate concentrations dropped to 1 milligram per liter. So obviously, to me, there's a correlation between the two. Plus, I don't remember if they did coliform sampling or not, but I think it was still there. But that doesn't. That's not really. I can't correlate that right now with the cows or not. The TDS samples, they also were about the same, a little bit lower. But my contention is a lot of the water you see there is due to leakage from the canal. Groundwater, when they removed the animals, was at 18 feet. When they put the monitoring wells in, it's at 6 feet. So depending on how much water is going down the canal, when they're irrigating the crop land, you'll find different groundwater elevations. So what I saw was that the cows definitely had an impact on the water when they were there. But after they were removed, the flushing from the canal basically helped clean that water up a bit, right in that vicinity of where the cows were located.
Will you remind me of the time between the first grab sample and the second?
I don't have that. Let me look here. I did not write down the dates of those samples.
Do you have an approximate recollection?
June 2012 was when the first samples were taken. November 2012 was when the monitoring wells were installed.
And then I have another question. It was mentioned that the groundwater in the area is not suitable for drinking water. Is that the case? And I have a genuine human health concern about, especially the coliform and the E. coli in the water. And are people, because there are houses nearby, and are they tapping into that groundwater?
I don't know where they get the water from, but my estimate is that almost every farm out there has its own water well. There is a community located a couple of miles to the northwest of ranchettes, 5-acre parcels. All those are on individual water supply, on individual wells. So it's not, the water is relied upon by the community for drinking purposes. The TDS is fairly high. If you look at where their expert asked that the concentrations at the sugar beet factory upgrading it were high, and they are. But if you look what is upgrading of that sugar beet factory is the City of Tracy wastewater treatment plant unlined ponds. So essentially upgrading of them is a high TDS source. If you go to the Tosta dairy itself where groundwater samples were collected, in the middle of the dairy, really very high concentration TDS 17,000. But if you go off that property on either direction, the 2 wells that they put on that property, the concentrations did drop down to in the range of 5,000 to 7,000. So TDS is very high. It's probably not very palatable to drink that water, but at 5,000 TDS, it is usable.
And it sounds like there's a very likely chance that people are using water that has
Correct.
coliform of these levels.
Oh, coliform we have not sampled, or the coliform concentrations were not tested for in anybody's water supply well, so I can't answer that question.
Okay, thank you.
One thing I would point out as well, in relation to that question, is that the basin plan, which the Dairy General Order implements and is designed to protect all beneficial uses listed in the basin plan, and the basin plan does list all groundwater in the region as suitable for municipal purposes. So that's a designated beneficial use that our orders are designed to protect.
Any further discussion? Yes, Ken.
I just wanted to mention, as you're aware, Alex McDonald was on the team to look at the groundwater information. Richard Lankarovich was on the advisory team to look at the financial information. So if you have any questions on that,
Thank you.
we do have somebody who looked at that in detail.
I appreciate it. Thank you.
Carl?
Yes, Bob?
Just as an aside, I'm kind of wondering why there isn't a criminal case here too. But that being said, the thing I have is, you know, that the 504 days collapsed to 22 days is like 4%. I'm more comfortable like at a number at 10% or something, but
Well,
I don't know why. I didn't ask staff why they got to that amount, but that seems.
I think I can answer that question. The way the enforcement policy works, under my understanding, is if the conditions have been met for collapsing, there is a very specific manner in which that collapsing is done, and it's specified in the enforcement policy where the first so many days are assessed, and then you get into that intermediate period of time where there with each 30-day period that transpires, instead of 30 violations assessed, it's only one, and that's prescribed in the enforcement policy. And in reviewing the worksheet, that's how the prosecution team arrived at this number of, so the board wouldn't have discretion to, you know, change that formula of collapsing. It's set in the.
All we could decide to do is not to collapse, in which case this would be a serious number, I admit.
Right, you would, on collapsing, there are other areas that the board has discretion on in terms of the other factors that are laid forth in that attachment A. But in terms of collapsement, if that's a word, yes, it's either no collapsing or collapsing according to the enforcement policy.
well, on behalf of Mr. Tosta, Mr. Terps testified or made the statement that we should be changing the severity factors in the formula. I'm not in agreement with that. I think this was a severe violation, and quite frankly, I like the formula the way it stands right now, Bob. Any further comments? Yes.
I have some comments. As an attorney, I appreciate that Mr. Tepstra is, representing his client in almost a pro bono fashion. So I'm glad that Mr. Tosta can count on a defense. And I understand also the position that in administrative hearings and in all civil cases that you're just not provided a defense, and that it's sort of every person for themselves. And sometimes people get sued without reason, and those poor people have to put up a defense too. And sometimes when there is a reason, those people got to put up a defense too. So, it's very rare, I think, when in a civil case, the discharger, the defendant, can put up the kind of dream defense that they would want with experts and, a whole, table full of attorneys. I mean, who wouldn't want that? But the truth is that legal counsel, like complying with administrative orders, is cost of doing business. And, I am sympathetic to how hard it is to have your own business. And, I don't know. I'm not happy about collapsing the days either. I kind of saw this penalty and the evidence, and I did read the defense's submissions, but I gotta tell you, I was very, very unsympathetic. I thought that the numbers were too low given the severity of what I saw. In particular, what I found egregious is that, as we heard in staff's testimony today, is that some of these cows were brought off-site from somewhere else onto the site, and buried or put near a water body, you know, and I mean, that's really bad. I mean, not only is it bad to consciously decide to move cows that you know probably should be tallowed, or you would think that someone in business would know that, but you know, to move them somewhere else and put them next to water, I mean, that's really, really bad. You know, and then with the calves and everything else being buried right next to water. So we have shallow water. Not only is that already a problem, but then you've got people purposely moving animals, decomposing animals, or for moving them there for the purpose of decomposition right next to water. I mean, I don't know how this could get any worse. I mean, as far as on a egregiousness level. So, you know, to me, the fine seems low, but I mean, I see his financial, Mr. Tosta's financial condition, and I know it's hard to run a business, but, you know, regulations, you know, be they bar dues or professional malpractice insurance, I mean, whatever it is that you have to comply with, those are real expenses that you have to put up with. So, you know, if it's too expensive to do business, I understand, but not having the money and not complying is not an excuse. And
Right.
so I think you guys can get where I'm going, so I'm just gonna quit there.
Well, are you prepared to make a motion before you quit?
Before you do that, Mr. Chair, if I could correct myself, I apologize. Board Member Schneider had asked about collapsing, and I reviewed the enforcement policy during this discussion, and it's actually written in a way that does give the board some flexibility. The limit is there's a minimum collapsing that can be done, but the way the policy is written, it says in the cases when collapsing occurs, the liability shall not be less than an amount that is calculated based on an assessment using the formula. So while typically the formula is used to do the collapsing, to technically answer your question accurately, there is some ability to do what you were saying in terms of percentage of collapsing. I'm not saying it would be easy or not complicated, but there would be a way you would go through the worksheet, go through the spreadsheet, and figure out a way to express how, not using the standard formula, but some other formula above what is proposed in the ACL order. Thank you.
Bob, do you want to pursue that further?
Well, I want to, but I think discretion here is I would make a motion that we approve staff's recommendation.
Thank you. Do I have a second?
I'll second.
It's been moved and seconded, moved by Bob Schneider and seconded by Carmen Ramirez, that we approve this motion, this item. Yes?
Can I, now that I see what the motion is, there was one correction that I wanted to suggest to the board in terms of the finding on ability to pay.
Yes.
That's in the late revisions that were passed out for attachment A in your packet, and on page 10. So the purpose of my proposed revision is to fully elaborate what evidence the board considered in reaching the conclusion regarding ability to pay. As it reads right now, the ability to pay conclusion is informed by a listing of land holdings and an operation, and then plus you see down in the last paragraph there is a reference to an analysis by Gerald Horner. I think it's more accurate to the final order to summarize what other evidence was in the record regarding this question of ability to pay. And I have language here that I could suggest. for the board's consideration, if that would be included
go ahead
in the
and
motion.
Go ahead.
So you would strike that first, towards the end of the sentence that reads, additionally, the discharger's ability to pay. You would strike at the end of the sentence the clause that says, is supported by the analysis conducted by senior economist Dr. Gerald Horner. You would strike that part and you would replace it with the text, was further informed by review of Tosta Dairy LP's tax returns from 2008 to 2012, Gerald Horner's memorandum dated 14 January 2014, comma, and Mark Furman's declaration dated 18 July 2013. And so, in my opinion, that better summarizes the information that was in the record that the board considered in agreeing with the ultimate conclusion, which is stated at the end of that sentence, that the discharger has the ability to pay and continue in business. I think it's just a more accurate characterization of the record.
I'll accept that.
You'll accept that into your motion as part of the late revision, which was incorporated into that, is that correct? And Carmen? With your second.
I'll continue with my second.
Yeah, thank you. Any further discussion? If not, we'll vote. This is a voice vote. All in favor of the motion as with late revisions, state so by saying aye. Aye. Opposed, say no. Abstentions? Motion carries. We are going to be adjourned until tomorrow morning at 9 o'clock when we begin with the Friday segment of our meeting. I did not bring up the minutes from the past meetings to vote on today because tomorrow we'll have John Constantino will be joining us, and given the abstentions I expect on some of these, it'll ensure that I have a quorum on all the minutes. So, Ken, please make absolutely certain that I vote that we vote on these tomorrow. Thank you.